Good morning, everyone. It is noon here on the East Coast. Today is November 1st. We are starting to creep close to Christmas already, as I'm sure all the stores are going to have all their Christmas stuff out. Today, we will be discussing all things California and all things federal lawsuits. We have Chuck and Josh here from California, myself and Avis from the client relations team, and we have our business guru Hank here, who we're going to let take the floor for the first couple minutes, and then we're going to turn it over to the California boys so we can let Hank get back to some important business. So good morning, Hank. What do you got?
This is important business too. I don't want to diminish that whatsoever, but glad to be here. And just as I was mentioning earlier on, just finished sort of a Midwest tour of the country, hitting up some retailers, getting a temperature of the industry, and some of the consistent things that I'm seeing out there for you folks. Kind of up and down. Depends. Some folks are saying the market's really pumped the brakes hard, and other folks are saying they're rocking on and doing really good business. The consistencies I'm seeing when I look at the bigger picture is the folks that are still doing strong business are getting out in front of the customers with marketing and being relentless about it. And the folks that are struggling are just kind of on cruise control. So for this last quarter, which for a lot of shops is the critical, quarter for the year, that last quarter, whether you're going to be profitable or not, spend the marketing dollars, get out in front of customers as much as you can. It seems to be the big difference between busy stores and slow stores right now. On top of that, though, in a more pressing kind of matter, I'm getting a very, very strong indicator that Black Friday this year is going to be all about ammo and folks getting out from underneath their off-brand, the stuff that they're in a too high of a cost per round position with the market pulling back on the cost per rounds. There's a lot of folks out there with excess overpriced inventory where they're 10, 20 cents over what current market is bringing per round. And they're looking to use Black Friday as a way to try and turn make a person from a sow's ear kind of thing and say, hey, I know I'm going to take a bloodbath on this inventory, but hey, to use it to try and attract customers into the store, maybe that's my escape valve that I can turn it into a positive. So be very cognizant of market prices that are being advertised, and you'll probably start seeing some of it soon for Black Friday sales, and say to yourself, where do I want to be in that mix? Do I want to play that game, or do I want to meet them close or whatever? But you may see some migration away from your stores on ammo sales because of folks that are going to have some very sharp pricing coming into Black Friday this year. So be very, very cognizant of it. The other thing I'm advocating to a lot of my accounts out there is keeping a very close ear to the track over the next few weeks in regards to the COVID doses that are going to be approved for the 5 to 12-year-old bucket out there. That it could create some local pockets of civil unrest with parents going to board meetings, especially if suddenly this COVID vaccine becomes required for attendance at school. You think adults get all in a tizzy when they're being told what to do. You start telling them what to do with their kids, and you see a whole nother level of resistance and difficulties. So keep a very close ear to the track of what that's looking like in your local area. Because of that fact, you may see some spikes in business in your market, especially if because of the Attorney General letters that went out, getting the FBI involved at school board meetings. You'll see some local pockets of civil unrest, which may spike business in your area. So be on the lookout for that stuff as well too. So, but again, the main points are Black Friday. Be aware that it's probably going to be an ammo-centric Black Friday this year. So make sure you position yourself properly. Market. The stores that are being consistently successful right now are marketing very heavily to their customers and making them aware of, hey, I've got this in stock, and come into my store and check it out. And then just, again, keep your ear to the local politics of the COVID vaccines for the kids. That's going to be here in the next week, 2 weeks. But that's about my market summary right now for folks out there is just make this last quarter awesome.
I appreciate it. Thank you very much, sir. It was good seeing you.
Thank you. Glad to see you guys again. Sorry I missed you last month.
Not a problem. We'll see you again in a couple of weeks, man.
All righty.
So with that, I'm going to go ahead and hand it over to Mr. Chuck Michele out in California. Chuck, you and Josh, go ahead and feel free to distribute the floor up as you may see fit and let us know what's going on.
Okay, well, Josh, what are you talking about? I'm going to talk about the Supreme Court argument coming up.
I'm going to talk about mask accommodations for employees.
Okay, why don't you go first?
All right. So happy Dia de Muertos to all of you people who know what that is. We celebrate that out here in California. You probably don't, but happy Day of the Dead. And speaking of dead, I'm going to beat a dead horse talking about some of the accommodation issues that we've talked about over the past several months. And, we've talked about, complying with the OSHA regs. Now I want to talk to you about a scenario that some of you may face. We know that you don't have to, at least in most of California, require your vaccinated employees to wear masks in the store. But you know that if they're unvaccinated, then you have to require them to wear masks. So you guys may face a scenario where you have unvaccinated employees who are asking to not wear a mask, and they're claiming that they're doing it because they have some sort of disability that prevents them from being able to perform their duties or be able to breathe or something like that while they're wearing a mask. And I know a lot of you guys saw this with customers very early in the pandemic, where they'd go and they'd print out, and we talked about this, they'd go and they'd print out that little card that said ADA, Federal Disability Enforcement Administration, and they would try to come into the store. And at that time, a lot of you were facing local health orders or state health orders that said you can't let anybody unmasked into your stores, and you had to limit it to 25%, et cetera, et cetera. And then but these folks would come up and go, I have a disability and here's my disability card to prove it. And I know you guys had a lot of fun with those customers. So what do you do if you have an employee, similar situation, legitimate or illegitimate? They're saying, I can't wear a mask. I'm unvaccinated, but I can't wear a mask. What's your obligation now in the pandemic under the ADA, under local law? So if you get faced with this scenario, I'm going to walk you through the steps. I'm going to tell you what you can do and what you can't do. The first thing you absolutely cannot do if you face that situation, employee doesn't want to wear a mask, says, I have a disability. You can't ask them what their disability is. Don't ever ask an employee, whether it's COVID or any other claimed disability completely unrelated to the pandemic. Don't ever ask an employee, okay, well, what's your disability so I can assess it? This is part of the dance, and we'll talk about this interactive process of figuring out how to accommodate an employee. But the first part of the dance is you can't actually talk about what the disability is. The first rule of Fight Club is you don't talk about Fight Club. The first rule of disability accommodation is you don't ask about the disability. What you do ask is you ask whether the employee can perform their essential job functions with or without an accommodation. Well, that's a pretty tortured thing to ask, but that's how you approach it. They say, I can't wear a mask. I can't do my job with a mask. Okay. Your response should be, well, can you perform all your job functions with or without some sort of accommodation? And this is what we call starting the interactive process. And if they say, no, I can't, I need an accommodation. I need to not wear a mask. At that point, your next step as an employer is to say to them, okay, well, I need documentation as to what sort of accommodation you need, because I know you're telling me that you need to not wear a mask, but I need to hear from somebody a little more authoritative than you, i.e. your doctor, what sort of accommodation you need. So typically what then an employee will do is they'll go to their doctor and they'll get a note. And if their doctor knows what they're doing, the note will have sufficient information for you as an employer to be able to say, oh, okay, they need some sort of accommodation that allows them to breathe better, or they need some sort of accommodation that allows them to sit down every 20 minutes. Here is what a good doctor's note will have. And this is what you should look for when your employee gives you a note trying to get an accommodation. It will confirm that the employee has a disability. It won't necessarily tell you what the disability is. It will state the extent to which the employee cannot perform the essential job function, and it will recommend a specific accommodation. Now, remember, your role as an employer is to provide a reasonable accommodation. And what a reasonable accommodation is, it's one that you can provide that does not cause an undue burden on your business operations. So a reasonable accommodation might be, okay, you get a break every 20 minutes because you can't stand for that long. That may or may not be a reasonable accommodation. An unreasonable accommodation would be, well, okay, we're going to hire another employee to help you perform your job duties because you get so winded from doing your job duties that you can't perform all of them. That would be unreasonable, because you have to hire a whole nother employee. That's a significant interruption to your business operations. It's a significant cost. Now, we talked about what's in a good doctor's note. It confirms that the employee has a disability. It indicates the extent to which they can't perform the job functions, and it'll recommend a accommodation. But what if you get a doctor's note and all it says is, please, Mike cannot wear a mask. He has a disability. What do you do then? You can ask them, you can say to the employee, I'm sorry, this doesn't provide me enough information. You need to provide me supplemental information. And in fact, at the point at which you either are starting into the interactive process with an employee, or at the point at which they've given you a doctor's note, but that doctor's note is not good enough, you should have a form ready that includes the 3 questions that I just asked. Do you have a disability? It should ask the employee's doctor, does the employee have a disability? To what extent can they perform the job functions? And what accommodations do you recommend? Give that to the employee to give their doctor, and they will hopefully bring it back, and it will provide you with sufficient information. But you do need to give the employee an opportunity to supplement the information. If they bring you a bad doctor's note, or they, you get something that you just go, this is bunk. I can't believe it. You can't at that point go, well, I'm sorry, this isn't good enough, so I'm not going to accommodate you. If you do that, and the employee can later come back and claim that you didn't engage in this interactive process with them over their accommodation sufficiently enough, and you have in fact engaged in disability discrimination. So you don't want to do that. Give them an opportunity to supplement. So let's talk about some examples of in the context of an employee who's saying, I don't want to wear a mask. Let's talk about what's good proof versus bad proof. So example number 1, an employee says, my doctor says I need to not wear a mask. Obviously, that's not good enough. You're entitled to some more documentation. You're entitled to documentation from their medical provider. An employee complains that they feel lightheaded after they wear a mask for 20 minutes. Again, that may or may not show that they have a disability, but you're entitled to more information. Or the employee shows up with the doctor's note that says, Mr. Smith shouldn't be permitted to wear a mask at work due to a medical condition. Again, that doesn't really tell you whether or not whatever condition Mr. Smith has, that reasonably wearing a mask would or would not be reasonable. What those situations, again, they're not good enough. So you have to ask them for supplemental information. You also at that point are in the interactive process. So for example, one of the ones we talked about was the employee complaining they feel lightheaded. They're not saying I have a disability, I need an accommodation. They're going, ooh, I'm feeling woozy after wearing this mask. I really don't like wearing this mask. They may not be specifically asking for an accommodation, but at that point, if you as an employer are reasonably perceiving that, oh, they've got a disability issue, and it's an objective standard. So you can't just go, well, I'm going to pretend like I didn't see them engaging or having this issue with their being lightheaded with the mask. You can't stick your head in the sand. If a reasonable employer in that position would go, well, wait a second, they're having an issue with wearing a mask. You as an employer at that point have the opportunity and the obligation to go in there and say, okay, do you need an accommodation? Can you perform your essential job functions with or without an accommodation? You have that obligation regardless of whether an employee asks you for an accommodation. or tells you they have a disability. The defense of the employee never told me that he or she was disabled is a very bad defense if you get sued for disability discrimination. So remember, even if you're not getting an overt request for an accommodation, nonetheless, you should be engaging in the interactive process if you objectively have information like, I'm feeling lightheaded when I wear a mask, that tells you that the employee is suffering from something that could be a disability. So let's talk a little bit about reasonable accommodations. What's a reasonable accommodation for an employee that says and provides documentation that wearing a mask for extended periods of time affects them in some way due to a disability, a breathing disability, a psychosocial disability, whatever their doctor has documented as potentially being a disability? Well, we know from, when you got to listen to me pedantically talk about the new OSHA regs that went into effect in June, we know that wearing a visor can be considered an appropriate alternative to wearing a mask when somebody can't wear a mask. That's written right into the new Cal OSHA regs. So that in and of itself can be a reasonable accommodation. And the only question at that point becomes whether or not that accommodation, if that's what you have to do, if that addresses whatever the claimed disability and the claimed accommodation from the doctor is, and also whether or not how it affects your business operations. And I know that there are certain folks out there, certain customers out there, that they may walk into a store and see somebody working as a retail cashier and they're wearing a visor instead of a mask, and those folks might freak out. I mean, they're just out there, and for whatever reason, seeing an unmasked employee might just sort of set them on edge. You may not want your retail cashier wearing a visor. That may not be a reasonable accommodation for their particular position. In most situations, I imagine it would be. But just remember, again, under the OSHA regs, they can wear a visor instead of a mask. And so because of that, you have a very good argument that that's the most reasonable accommodation. Now, again, if there's something on the doctor's note that suggests that might not work, then you're going to have to look at something else. Other reasonable accommodations in that situation would be, for example, retail cashier, rather than making them wear a visor. You don't want to freak out the customers. You could transfer them to some other area of the workplace where they're not interacting with other employees, but they still would have to wear a visor because that's the OSHA reg. But that might be an appropriate thing. A transfer, it can be an appropriate, reasonable accommodation. Remember, under ADA law, though, you can't do something that's considered a punishment or a demotion. So if you're transferring somebody from retail cashier to the back to wear a visor and, let's say, clean toilets, that person may go, well, wait a second, this is a demotion. I'm not a janitor. And even though you may be paying them the same amount of money, if objectively their job duties are less prestigious or more difficult, or other indicia that it's something that's less desirable objectively as a job, then they can potentially argue that you're engaging in disability discrimination because you're essentially punishing them. Oh, okay, you don't want to wear a mask and work cashiering duties. I'm going to put you in the back lifting heavy boxes, even though that's never been a part of your job. Or I'm going to put you in the back cleaning toilets. So here's an interesting question. Is working from home, is telecommuting a reasonable accommodation? And I will tell you, there's been a couple of regulatory opinions out there that suggest that yes, it might be. Now, for retail employers, I don't know that it is, particularly if you need people on the floor interacting with customers. I don't know how you would transfer somebody to work at their house and still have them be able to perform their essential job functions. And that's the test. Remember, it's whether or not the accommodation still allows them to perform their essential job functions. You're not obligated to create an accommodation for somebody that doesn't allow them to perform their essential job functions. You don't have to say, oh, well, I know we need you as a cashier, but so that I don't get sued under the ADA, I'm just going to have you sit here in a chair for the next 8 hours, and I'm going to pay you an hourly wage to do that. because I don't want to get sued. No, that you're not obligated to do that. You are only obligated to do something that that allows them to continue to perform their job functions. But working from home may continue to allow them to perform their job functions. For example, if you have a buyer or somebody who's interacting with distributors at your store, and they're usually sitting in the back, and they're going online, they're ordering stuff, they're checking on stock, on the computer, they're checking stock of different types of stuff you guys sell. They may be able to perform that from home. They may not have to be there. So remember, you don't necessarily have to. You're not obligated to allow somebody to work from home as an accommodation, but there may be certain circumstances where if there aren't other reasonable accommodations, working from home may be required. And by the way, just sort of as an aside here, pre-pandemic, there are, as you folks who are employers know, California has about 4 different types of leave. There's federal FMLA leave, there's the pregnancy disability leave, there's California family leave, and all of these have different timelines. But in theory, if somebody goes out on, exhausts all their various leaves under federal and California law, and they don't come back to their job, or they can't come back to their job, you as an employer normally have the right to terminate them. You don't have to hold a job open if the employee won't come back after they have exhausted their leave. Well, notwithstanding that sort of general rule, there have been lots of court cases over about the past 20 years that have said in certain instances, a reasonable accommodation may include extending somebody's leave. So, and you go, well, shoot, how am I as an employer supposed to figure out whether I'm obligated to extend somebody's FMLA leave a certain amount of time to accommodate their disability that they're essentially taking that FMLA leave for? And it's not an easy question to answer. I can tell you the cases out there that have said, no, employer, you should have extended their leave as an accommodation under the ADA. Usually they say a couple months, but a year to a year and a half, they'll go, no, that's too long. The real test for you as an employer is going to be how much of an undue hardship is it on you to extend that employee's leave? Are you a two-man shop where extending that employee's leave is essentially going to hobble your business? Are you a 25 employee shop where no, we can have other people fill in for that person's shifts? They're just a floor salesperson, and we've got other floor salespeople. So that's the test. As a general rule, I would say if you're ever confronted with a situation where an employee goes, I'm running out of FMLA time, but my doctor says that in order to continue my rehab from this thing that's very clearly a disability, I need another month. You would be in a position there where you'd have to seriously consider, okay, well, I'm going to have to extend their leave. If they say, look, I'm going to be doing this rehab, and it may be a month, it may be 8 months, it may be a year and a half, you would go, okay, well, I'll give you the month. But then after about a month, if they're not committing to come back at that point, you can go, okay, well, I've accommodated you as much as I can and still keep my business open, so you're fired. So that leads to another question. What's the disability versus what's just a transient condition? What's the difference between having something that affects a major life activity that would be considered a disability versus something like a cold or a flu or something that's transient that wouldn't be considered a disability under the ADA? And is COVID considered a disability rather than a transient condition? And I will tell you, COVID, so you get an employee that gets COVID and they go, I need an accommodation. Generally, you're not obligated to accommodate them and their COVID condition as a disability. You may have to do other things like we talked about under the OSHA regs. You're going to have to, implement quarantines and, let them take their 14 days and testing and all that. But as a disability, generally coming down with COVID is not something that an employee can say, I have a disability, you now need to accommodate me. You need to allow me to work from home as a disability accommodation. But certain conditions that are potentially permanent that may arise from COVID might qualify as a disability. So somebody gets COVID. COVID isn't something that you have to accommodate as a disability. You do have to go through all your OSHA steps with that person. But let's say after they come back, they say, and they provide a note that says they developed rheumatoid arthritis as a result of getting COVID. And we've seen some kind of weird stuff like that. We've heard about the myocarditis. We've seen some other weird sort of lingering symptoms. Let's say a doctor says they developed rheumatoid arthritis as a result of COVID. And now they're saying, well, I can't lift these heavy boxes because I got this rheumatoid arthritis in my lower arms and they're hurting. And so are you obligated at that point to accommodate it? And the answer is, to the extent you can, then yes. So you may have to buy them elbow braces. You might have to give them stretching breaks. You might have to give them modified duty if they're doing something where they're lifting lots of heavy boxes and they can't do that now as readily because they have rheumatoid arthritis. So some of these lingering effects of a COVID infection we've seen that may end up requiring you as an employer to provide an accommodation. You may have to provide more frequent bathroom breaks. You may have to address issues where people are chronically tired. And then if they develop chronic breathing issues as a result of a COVID infection, we've heard of, some of those lingering symptoms too. These are all things that even though they arose out of this disease that isn't considered something you have to accommodate, because they are now long-term conditions, they're not transient, and they impact the life activities of your employees, you have to accommodate them. So, and by the way, there may be certain circumstances where they've developed these conditions and telecommuting, working from home is the only reasonable accommodation. So on that last issue here, before we wrap up, just remember, whenever you're assessing an accommodation, including telecommuting, working from home, or any other accommodation besides wearing a visor, you have to go back to the comparing what the essential functions of the job are, retail cashier, and doing the inquiry of whether or not the accommodations you could provide or considering providing would impose an undue burden on your business. You don't have to hire new employees, you don't have to create new positions, but would allowing this person to sit down 3 times in a 60-minute period, would that cause an undue burden? Might not for somebody who's working back in the stock room, but it might for somebody who's working the floor as a salesperson or retail cashier, because you have somebody sitting down for 5-10 minutes sitting there while people want to get rung up or people want to ask questions about a particular firearm. So remember, that's the balance. What are the essential job functions? Is what's being proposed or considered as an accommodation, will it cause an undue burden on my business? So hopefully that'll help you guys out. I'm hoping you don't get too many employees who are asking for that sort of accommodation, but if you do, you got a little roadmap here. And if you guys have any questions about these issues, feel free to ask questions through the help desk, and we'll see if we can resolve for you.
You're muted.
Did you make Chuck cry? He had to wipe his eyes after that. That was
that was painful. The labor laws in the state of California are right on par with how screwed up the gun laws are in the state of California.
Well, now tell us how screwed up the laws are, Chuck. It's all yours.
Well, okay, so I'm just going to talk about the Supreme Court. There are a few new laws that have been signed by the governor. The ones that I've been focusing on are the gun show bans, which CRPA will be filing multiple, has already filed one and will be filing multiple more lawsuits. We already won once against Del Mar when they tried to ban the gun show there because the federal court agreed with us that it's a First Amendment violation, believe it or not. So the next call, Matt can give a more detailed briefing. He couldn't get here for this one on the new laws that are coming into effect. Also, my new book, my new edition of the California gun laws book should be out shortly after Black Friday. So you can pre-order that on CRPA's website right now. But I want to talk about today, I want to talk about the Supreme Court oral argument that is coming up on Wednesday. that everybody really on this call should be listening to, and give you a little idea of the kind of thing that you should be listening for when you listen to that argument, or be aware of when we wait for a decision on this. So the oral argument in the New York State Rifle and Pistol Association v. Bruin case, which is the challenge to New York's requirement, similar to California, that you demonstrate a special need before you can get a permit to carry a gun in public, is scheduled for Wednesday. There will be 3 lawyers arguing. One is Paul Clement, who has argued before for state associations, and the other is Barbara Underwood, who's a New York Solicitor General. She gets 20 minutes. And then Brian Fletcher, representing the United States and the Biden administration. They horned their way into this case so that they get to argue for 15 minutes too. And they're going to argue that this law is constitutional, should not be struck down. Basically, though, what the law does is make the right to bear arms in public a privilege rather than a right, because you have to have some kind of a special qualifying factor. And in California, that's usually like a death threat signed with a phone number of the guy who's threatening you before you can get a permit. So the big question is going to be, what is the appropriate standard of review? How do you judge whether or not a gun control law is constitutional or not? And there's 2 approaches to this that are being argued. One is there's this two-step analysis. It's kind of like this First Amendment argument. Is it within the scope of the right? And then how bad is the infringement? And the other is that text, history, and tradition. You don't get into empirical evidence. You don't get into statistics. You don't get into policy decisions. You just evaluate what the framers' intention was when they passed a law, or the authors. If it doesn't just apply to Second Amendment, it could apply to any law. It's called the originalism approach to evaluating the constitutionality of a law. And so there's originalism, text, history, and tradition versus tiers of scrutiny. And then there's this argument, rational basis, intermediate, or strict scrutiny. How much scrutiny are you going to give a law, and how much deference are you going to give to the legislator and whatever bullshit findings they may put together to try and justify a law when they pass it? So that's the big argument. Now, if the Supreme Court goes with text, history, and tradition, the originalism approach, then all the cases, and there's hundreds that have been decided since McDonald in 2010 that went with this tiered analysis, will be able to be relitigated. So anything that we lost, we could conceivably sue again and use the new test and then see if there's a different result. So what should we be looking for? Well, the new Trump appointed justices, Gorsuch, Kavanaugh, and Coney Barrett, are supposed to be on our side. We believe that's why they took this case, and also why they took the previous New York case, which was then rendered moot by the state because they repealed the law. Those 3 judges have issued decisions respecting Heller and urging a different approach to judging of the constitutionality of a law. So they should be on our side, although they're not. It's not completely locked in. They weren't deciding a public carry case, but they should be locked in. Then you got Roberts. He's wishy-washy. He's afraid, basically, to go too far, even though he was very strong on the Second Amendment in the Heller decision. We don't know exactly where he'll come down, but we shouldn't need him because we have Alito and Thomas that make up the 5. So the thing that was holding us up before was Kennedy. He was afraid to take a case. But Thompson and Alito had been saying in dissents when the Supreme Court declined to take a case, those judges had been saying we should have taken that we're leaving all these unanswered questions and it's time to answer these. And they were very pro Second Amendment in their dissents that they put out, urging the court to take the case. Not surprisingly, the other side has tried to make this into a racist issue, call the case racist, and I think Justice Thomas is going to slap them down for that one, which he kind of did in the Heller and McDonald decisions, because they tried to talk about racism, and he wrote a big section of the McDonald opinion about why this is not racist, and in fact, gun control laws have been used to disarm various races, and so it's racist in the other direction. But the state did spend a lot of time developing a historical analysis, and this is where gun control litigation will go if they get rid of this two-step tiered approach. You won't have these statistical arguments anymore. You won't be deciding whether or not a gun control law is good policy based on what a politician says it does, which is usually a lie. They say it makes you safer, and in fact, it doesn't do anything of the kind. It's part of an agenda that they want to advance. But if we get this text, history, and tradition, there will be a lot less of that. And that's a good thing, because it's very expensive to do this kind of discovery and bring in these experts who present these reports, and then they get rebutted, and there's an expert that says they're wrong. And it's just very expensive to depose all those people and present that evidence. It would be good if we got rid of that. But what will happen then is you will get this flood of historical scholarship about what these gun control laws did and why and who thought what of them when they wrote them, because they'll try and justify these laws based on history and tradition if the test changes. So there'll be a different field, and I think an easier field, but and I think it'll be better than the tiered analysis with all the statistics and experts. So 4 things could happen. The court could strike down the New York law and adopt the text, history, and tradition approach. The court could strike down the law and retain this tiered analysis approach, standard of review, or it could uphold the law and adopt text, history, tradition, or it could uphold the law and adopt and retain the two-step tiered approach. It's quite possible, if not likely, that you'll get sort of a mishmash of sub-opinions, like a split opinion among some of the justices, some saying this is the appropriate standard of review, but if the majority applies a different one, it will say, well, it should still be struck down under the other standard of review. There's likely to be, there's certainly plenty of room for different opinions on different parts of the analysis of this thing. But the case is nonetheless significant and could be a complete game changer and a hard reset, especially in California, where we have such extreme gun control laws. It really could give us the opportunity to go after a bunch of the laws that are on the books now, because they don't really do anything other than turn good people into accidental criminals, or make it harder to buy or possess or carry a gun. So we're hoping that obviously they go with this traditional approach, and we get to relitigate all the cases that have been litigated over the last 10 years, and that we don't have to deal with this empirical studies and experts anymore, and it becomes sort of a clearer, I say this, and then Bloomberg's lawyers are going to come up with ways to cloud the issue no matter what. So theoretically, it should be easier, but who knows what will actually happen. But if we win, it is going to be a good thing, and quite likely change the field, change the battleground, and it is likely that we're going to win. It's just a matter of how far the court's going to go. So I would suggest everybody give this a listen on Wednesday, because it's going to affect your business and personal lives. Anybody got any questions? Okay, Brian? Going back to you, Brian?
He ran away.
Oh, okay.
So, Chuck, can you send me a link to where it will be, so we can send it out to all of our clients about where they can listen to the case? Do you know of a link?
It's the Supreme Court website.
Okay, all right. I'll add that to the email. All right, if that's all we've got for today, I think that's been great. Thank you for your information. I'll pass it on. And everybody have a great week. Our next meeting will be on December 6th, and we'll see you then.
All right, thanks, guys.
Thanks.